Turn to the next case on this morning's docket. That is case number 104176, State of Kansas, Misty Tague.
May it please the court, the defendant appears by and through counsel Kate Zigtema. I'd like to reserve 4 minutes for rebuttal.
4 minutes is granted.
Thank you, Judge. There's 2 issues I'd like to present to the court today, and I'll rely on my brief for the remaining issues. Those 2 issues are the application of the Berry Rule to this case, which I filed a 609 letter on, and then also the exclusion of exculpatory evidence, which was the lineups which did not identify the defendant in this case. I'll start with the Berry Rule.
Start by explaining to us your authority for presenting a new issue through a 609 letter.
Well, I filed a motion asking to be able to present that issue through a 609 letter, and that motion was granted.
You were granted the right to raise a new authority, but is that the same as being granted the right to raise a new issue?
I suppose not. Perhaps the better course of action would have been to request supplemental briefing, but since the court granted my request to do so and did not direct me to file supplemental briefing, I took that to mean that it was an appropriate means to raise that issue. That being said, I think that if supplemental briefing is necessary, I, of course, asked permission to do so before the court issued an opinion, but I'd like to proceed with argument if the court would allow me. The Berry Rule in this case, of course, would apply because this is a felony murder case. While the lesser included was not requested at trial, so this would be reviewed under a clearly erroneous standard. I think that there is evidence in this case that would support giving a lesser included offense instruction, a couple of different ones. For one, the defendant did present a alternate suspect defense at trial, but there was other evidence presented by the state that would lead, or at least make it possible, that when viewed in the light most favorable to the defendant, that a lesser included offense could result from a jury verdict. For one, it's clear that the co-defendant was the shooter in this case. He fired several shots into a small hotel room with multiple people in it. Somehow, he only struck the victim twice. Once in the thigh, which ended up traveling up and severing the arteries, which was the cause of death, and once in the hip. It's not a head shot. It's not a chest shot. It seems to be a blind, dumb luck. Somehow, this victim caught a bullet in his thigh that ended up killing him. I think that the reckless discharge, I don't think there's evidence to show that the co-defendant was aiming the firearm per se that would yield a kill shot such as this that resulted in his death. The alternate issue is that there is also some evidence that the victim pulled a firearm before the co-defendant fired the rounds of shots. And so there could be also, besides evidence of recklessness, there could also be some imperfect self-defense, perhaps, that could be considered by the jury so that lesser included offenses would be appropriate in this case and not just the felony murder instruction. But mostly I believe that given the nature of the shots and how many were fired, I think that there is sufficient evidence to show recklessness that would warrant a second-degree murder instruction, at least. The second issue, I'll move on if there's no questions, is that the district court's failure to allow admission of the lineup by 2 absent and unavailable witnesses was both a statutory error and a constitutional error. There is some issue as to whether or not this is appropriately before the court for review. I know the state raised that in its brief. I believe that it is. This is an issue that the defendant personally herself tried to raise and preserve before the court. Despite her attorney perhaps not following through as well as one would have liked, she raised that issue with the district court while the witness was still on the stand, questioning why they couldn't admit these lineups that did not identify her as the defendant, which would then be corroborating evidence as to her alternate suspect theory.
Where in the record is a hearsay exception ever offered to the court as a possibility?
There's not, because her attorney didn't actually participate in the colloquy. It was the district court that identified it as hearsay, and it's my position that because she was, in a sense, acting pro se in raising this objection, that some leeway should be given, that the court should have considered the exceptions, particularly because the state actually raised the issue of being unavailable. The state says we didn't just not subpoena these people, they're unavailable, we cannot find them. And
what's your authority that we apply a pro se rule to a person who is being represented? Where's their authority for allowing multiple representation in that situation?
Hybrid representation is typically not allowed, but I think in this case there is a sufficient record that shows the district court kind of went through a hearsay analysis, and the district court should have addressed it themselves, simply because I think there might be in the future a decent ineffective assistance of counsel. Of course, it's not raised on this case, but I think that the defendant should be entitled some leeway because she was acting pro se and did try to present the issue to the court.
And even if the judge were to guess at one of the exceptions, how is the foundation to be laid?
Well, the state laid the foundation. They presented testimony and proffered that the witnesses were unavailable.
Later? Wasn't that at the end of after the judge had made the ruling on the hearsay?
Well, there's not, the way it worked was the defense attorney cross-examined the witness, tried to bring it up, they kind of took a pause, the defense attorney tried to rephrase the question, then before they excused that witness, while the detective was still on the stand, they brought up the whole entire hearsay issue, but the witness was not excused yet, so there was still the opportunity that they could present additional testimony, and that was during the time that the state proffered that they had officers looking for it, and there's another officer that testified, I believe, I cited to it in my brief, that he tried to find them and could not find them, bringing up the unavailability issue.
But there was no renewal by the defense at that time of their request to have the evidence once that foundation was laid?
The defendant continued to question the court as to why they couldn't admit that, and the trial court said, enough, this is preserved from appeal, we're going to move on. And the trial court had the understanding that they had preserved the issue for appeal, and I think that hopefully will lead the court to conclude as well that they preserved this for appeal, because it's our position that it did.
Can you tell me exactly what evidence we're talking about?
What it was there were two additional witnesses, Starry Cross and Michael Davidson, that were present in the hotel room. They completed a written lineup that did not identify the defendant as the female perpetrator that committed the crime.
And the request was to question the law enforcement officers that provided it, to ask, did the other witnesses identify the defendant?
Right, to question regarding the failure to ID.
Is that hearsay?
I believe that it is hearsay because it would be those witnesses' out-of-court statements offered to prove that it was not the defendant to do so. I think that it qualifies as an exception because for one of two ways. I think that if you actually presented the written photographic lineup, which was at issue, that would be a business record exception, so it wouldn't be hearsay. It'd be an exception to hearsay. Photographic lineups are regularly done in the course of police detective work. They're subject to numerous protocols laid out by case law, and they have an indicia of trustworthiness prepared for litigation. I believe that those would qualify for the business records exception so that it would not be hearsay and that it could have been admissible.
And then if we get to that hurdle, why is this not harmless?
I think it's not harmless because her defense at trial was that another person did it. However, the evidence she presented that somebody else did it was perhaps not the strongest evidence. It consisted of her co-defendant who previously implicated her in the crime, recanting that statement and making a statement that, yes, it was her that was with me when I committed this offense. The independent failure of those witnesses to identify her lends credibility and corroborates and presents an independent basis to her alternate suspect theory that she pursued at trial, so that it's not just her co-defendant's word, which his word is subject to some back and forth. It provides an independent basis for her assertion that she did not commit the crime because they could not identify her. And this is particularly relevant because Mr. Davidson at trial, there was some evidence that the co-defendant testified the female suspect pistol whipped Mr. Davidson, who was then subsequently unable to identify the defendant. So that's someone who had up close and personal contact with the female suspect, who was then unable to identify her. It just leads to an integral, independent basis for her alternate suspect theory.
And just so I'm clear, your argument on the photo lineup itself is that it's non-hearsay or subject to the business records exception, but you agree that it's hearsay, that the cop's testimony about the failure to identify would be hearsay.
If he's saying they told me I couldn't identify them, that's clearly hearsay.
Okay.
But
right. I just wanted to make sure I understood your distinction you were drawing.
Right.
Okay,
but
thanks.
I would also think that the unavailable witness, they're actually saying I couldn't identify her, or that's not her, or I don't recognize her. That would be subject to the necessity unavailable exception, that then they could present that as an alternate
I understand.
means.
I just wanted to understand the distinction. Thanks.
If there's no other questions, then I'll rely on my brief for the remaining issues.
Any more questions of counsel? I see none. Thank you, counsel.
Thank you.
May it please the Court, David Loudon, Assistant District Attorney on behalf of the state. Like counsel, I will waive argument regarding the things that she did not discuss from the brief unless this Court has questions. And I will reluctantly start with the 609 issue. It's the state's position that if this Court considers that issue, and the state would ask this Court not to consider this issue based on the way it was raised and our limited ability to reply to that issue in a meaningful way under 609, the counsel's position is that they should have received a reckless second and a involuntary, which is based on reckless as well. The state's position is there is no evidence in this case regarding recklessness. The primary factual issue at the trial was identity. As noted in my brief, it was largely uncontested how this botched robbery occurred. Leslie Keith, or Country, you'll see in the transcript, went in with a female companion. They went there to rob somebody of drugs and money. Came in, he testified that he said, "This is a robbery, don't make it a homicide," and when Mr. Franklin drew a gun, that's when he was shot. Counsel is correct that there were a lot of shots in the room. However, that didn't turn Franklin's murder into a reckless murder. Every indication in the case is that he intended to shoot him. It wasn't just by chance he shot him. He shot him because he pulled the gun. He told him not to make it a homicide. For that simple reason alone, we would argue that counsel's request for those lessers is not appropriate or supported by the evidence. The second reason is because those lessers were not requested, this Court would try to get this right for Justice Johnson here. The test would be clearly erroneous. The standard of review would be unlimited de novo, I believe, on whether this was clearly erroneous or required. The evidence in the case, going to the first step, would be to figure out, is there any evidence that would support it? And as I've mentioned, there isn't any to indicate this is reckless. And even if this Court determines it is reckless, there's no indication from the facts that the jury would have found him guilty of either one of these lessers. The reason the state takes this position is the strength of the evidence in the way instructions are given in these type of cases when there are lesser included offenses. The jury is instructed, if there is evidence of this higher crime, you don't go any further down the list of lesser includeds. There's no indication in this case, there would be no indication in any case, that you can just start at the bottom, the least severe crime, and go to the top. You start at the top, you move to the bottom. In this case, there's no question whatsoever that there was a robbery that ended in a killing, and that satisfies felony murder. So for those reasons, we would ask this court, if it does reach the 609 issue, to sustain the conviction in this case. As far as, I believe it's issue 1 that counsel's spoken about with regard to the hearsay exceptions, as indicated in my brief, we quite clearly think that this court's decisions in State v. King and Richmond decide this issue. I suppose if there's something to argue about here, it would be whether there was a contemporaneous objection.
Well, let's look at something else. Would it have been proper for defense counsel to ask the law enforcement officer, did anyone else identify the defendant? Were there any other eyewitnesses interviewed, and did any others identify the defendant as being present? Or would that have been hearsay also? Seems to me questions like that happen all the time.
Where the question becomes the answer, you mean? Is that what you're referring to, Your Honor?
Well, did you have any other eyewitnesses that identified the defendant as the perpetrator?
Well, I think I think this goes into whether that question is the answer itself. I don't think that question requires a hearsay response at that point in time.
It's just a yes or no.
It's just a yes or no.
Yeah. So it's a proper question, at least on a hearsay basis.
It is, but we've had those cases where, where the question suggests the answer and the question
it's
has come
subject to a
up.
leading objection.
Right.
But
Right.
potentially, I guess. But it's not, it's just a yes or no question.
Right, and in this case, as noted in the brief, and I think as conceded by counsel, we never got to an objection.
But before we leave that topic, I hear you saying it would have been okay if the question had been framed, did any other eyewitness identify the defendant? But then if you ask, did the eyewitnesses A and B identify, then you're saying that then becomes hearsay. Are we splitting that hair and saying, well, that's a hearsay? That calls for hearsay, whereas did any of the eyewitnesses identify is not hearsay. Do you understand what I'm asking you? I'm having a little trouble splitting those hairs on what's permissible and
Well, again, I don't know that we ever got there, Your Honor. The state made an objection. The judge never made a ruling. Counsel offered to restate the question and apparently got out the information you wanted. So as this played out, I don't think we ever got there, and I think that's part of it, what makes it so difficult. Part of the state's position, at one point the state recognizes that...
Didn't the witness only get out half an answer? Didn't the witness get interrupted by the judge? Maybe I'm confused.
I'm looking at page 6 of my brief. It sets out that exchange.
I remember what you're talking about, that there was an objection by the state and defense counsel offered to rephrase and did so, and then the witness started to answer, but the way the transcript looked to me, the witness didn't finish the answer before getting interrupted. Isn't that right?
The way I have it
Yeah.
in here, that does not indicate
That's not
that.
accurate. Okay.
It says, were they able to identify, and right away the prosecutor says, Judge, they are unavailable. We cannot find them. This is hearsay. And that's when the court said any argument. And that's when the prosecutor says, is there I'd asked that this argument be made outside the jury, and the court just said, "Is there any argument?" And defense counsel said, "I'll try to rephrase the question." So we never got to the meat of the objection.
I understand that part, but then what followed that passage?
You may rephrase the question. Defense counsel says, "After you were showed the arrays to those two, did you have any more solid? Were you more convinced that Misty Tague was the proper suspect?" And the officer said, "What was my opinion at that time? Is that what you're asking me?" And counsel said, "Yes, after you showed arrays to those two." And the answer was, "I think my opinion was the same. I think I'm always." And then the court said, "Next question."
That's what I was talking
That's what
about
you're
right
talking.
there. Yeah. Okay, thanks.
Okay. So the willingness to move on without expounding or taking the opportunity to have an argument about the state's objection relieved the state or the court at that point in time to interject anything. It was following that exchange and the end of the testimony from the witness where the defense attorney wanted to approach and have a discussion because his client was unhappy about not being able to get that information in. From what I can tell from the record, and this court obviously will make its own decision, the only thing offered by the defendant was, "I think the report should come in." And that's not good enough. And counsel suggests that this is a business records exception. If that's the case, boy, we'll have them in we'll just put them in from the state. We don't need any testimony. And I don't think that the business records exception has ever been applied to a police report in that manner.
What do you think we do with the trial court telling everybody that the issue's preserved?
I think it's unclear. I've read this thing many times. My take on it was it's just at some point the court says, "Look, a lot of people are unhappy about the things I do, and you've told me that you're unhappy. That's the way I'm going to take it." The issue regarding the first question, I guess, is something that is preserved. But his opinion of whether it's preserved or not doesn't control the issue. I don't know that he was talking necessarily, and this is what I'm unclear about the defendant's displeasure with what went on. I don't think court was letting him make an objection. I think he was just listening to his complaint and saying, "We're going to move on," especially when that complaint didn't involve any legal basis other than, "I think that you should be able to put in the whole police report." And that's not a legal basis for an objection, even if it were. The objection came from the state initially, hearsay. When the defendant had his time to talk, he wasn't making an objection. He wasn't preserving an objection. He was trying to give a legal basis of which there was none. So this isn't about a contemporaneous objection on his part. It's just a disagreement with the court's the way the court handled it, and I think that's the way the court took it.
Well, one of the ways that the State versus King line of cases have been chipped away at has been whether everybody knew really what was going on.
Right.
And do I understand from your answer that the court statement here doesn't show that everybody really knew what was going on? It's just as far as what was being preserved and what was being talked about.
When you mean everyone, you're talking about the defendant or just
parties
and
yeah.
everybody?
Particularly, counsel in the court.
Excuse me, Your Honor, I'm just trying to look at the way he said it. I think that might help. The paragraph on page 8 of my brief where he's actually utters that statement is, "Now, if that's the issue," and I bracket in, "that defendant wanted to discuss, I'm not going to argue that issue at this point. It has been argued and it has been decided and it is preserved for appeal." Again,
another place where he says, "Okay, well, and I guess the sum total of it is with regard to those issues," which would be the things that were talked about previously with regard to those issues, that's an issue that's preserved for appeal.
Right.
So we started out with plural issues, and we
Right.
get down to single issue. But
again,
And
it
before
is
that, he
preserved for
said-
appeal, but it doesn't make it an issue that we can litigate with any meaning. I mean, again, there was no There was. It's our objection, and he chose not to litigate it at the time. And then when the defendant says, well, I want to litigate it on this basis, he doesn't provide any basis other than, I think it should come in because it's in the police report.
And doesn't, before the exchange you were just reading, the trial judge, it seems to me, specifically invites an exception. It says, and the rule against hearsay says you can't bring those things in unless it falls under one of the exceptions. I mean, as I read that whole colloquy, it seems to me like 2 or 3 times the trial court says, okay, here's your chance. Mm-hmm. Tell me what the exception is, and nothing's offered.
Mm-hmm. Well, and honestly, I can't say with 100% certainty, based on this colloquy, that the judge, if something did present itself that was legitimate, that the court wouldn't have accepted it, because I think counsel correctly said that the witness was either on the stand or he was still available. I don't know, I wasn't there, but again, that didn't come up. So now, if this court is going to review the propriety of the situation, I don't see anything here, and this is one reason we're bringing up Richmond, is these grounds that she's raising for relief outside of the business record exception, I don't think were even talked about at that point in time. So, with regard to all those, we asked this court to just rely on Richmond and not take those up. And with regard to the business record exception, to the extent that this court finds that it is a preserved issue, we'd ask that it doesn't apply.
So basically you're saying that when you say this is hearsay, that an eyewitness did not identify the defendant, we're saying hearsay includes an out-of-court non-statement, or silence offered for the truth of the matter asserted. Because we're not talking about, when you say did they identify, you're asking for a negative. No, they didn't. How is that an out-of-court statement?
It's not. And I'm sorry, we might have gotten sidetracked off your conversation, but it's not.
But doesn't it depend on how the questions are posed? Because had the detective said to these 2 witnesses, is that her? And the answer to that is no, then the answer, that no, does become hearsay.
Right. It does.
And so you can talk around it, and we all have done that at trial, but when you get to the heart of how would you know whether they actually had identified it, has to be hearsay.
And that's why my discussion with Justice Beyer was, I know we've had cases where we suggest that sometimes the question goes over the line and becomes the answer, and
that's what the lawyer was doing here. The lawyer knew he couldn't say the exact question and answer like I just laid out, so they went around a different way and said, "What did your opinion change after you talked to them?" Well,
and I think at one point the state said, "Look, if this person's statements come in, okay, regarding the lineup, there was a lot more that these people said that we can't even get into. So this isn't about protecting, as suggested by the defendant, protecting his confrontation rights. This is about a rule of law in Kansas that is beneath the confrontation right, that says in order to get a piece of evidence in, you need to satisfy the rule against an exception to the hearsay rule. There wasn't one at this point." So.
Could you address opposing counsel's argument that this is not harmless error?
Yes, Your Honor. The state believes that this is harmless error. Given the facts, and as I stated, the issue in the case was primarily identity. And you're assuming that if this evidence had come in, that these 2 witnesses did not identify, that's what you're regarding. If that evidence came in, I don't think it changes anything because the evidence led to the defendant. We had the testimony the statements from Leslie Keith to the officer who indicated that the defendant was there. He later recants, I understand, and at trial he testifies that he was just doing that out of being vindictive. But I don't think that sways in her favor when you look at her friend, her testimony, where there was no indication why she would have lied or been untruthful about it. But her testimony, she had a phone conversation about it, which indicated that she was there. But based on all that evidence, we think that the evidence, the error, if there was one, would have been harmless.
Good. Do we have any further questions of counsel? Thank you, counsel.
There's just a few final points, and I'll start from where Mr. Loudon left off. I think that there's a lot of conflicting evidence in this case. Even the defendant's so-called confession to her friend was kind of, sort of, maybe I just know about it, I wasn't there, I was there, but I didn't shoot anyone. So I think there's a lot of conflicting evidence in this case that we can't find that not admitting these independent lineups is harmless beyond a reasonable doubt, especially if you look at the entire record, which is what we're asking the court to do. I do think this issue was preserved. For one, the Kelly case has kind of chipped away at it's not necessarily objection hearsay like the law school textbooks. I think there's some leeway that as long as everybody knows what page we're on, then the court has had a chance to rule, the court has had a chance to change its mind, and then therefore it's reached and made its decision, which I think is exactly what happened here when the trial court says, this is preserved, let's move on.
Counsel, was the report proffered?
I don't think the report itself was proffered by counsel, but the contents were.
Is it an exhibit that we have?
I don't believe it's an exhibit that was admitted at trial or as part of the appellate record.
So how do we decide if there was even that question that Justice Johnson has been aiming at, whether or not it was phrased in terms of hearsay or not? We just have to assume it was hearsay.
Well, it wasn't part of the trial record, but they discussed the contents, and I believe the detective describes it. It was a 6-pack. It was the standard lineup procedure, I believe, is what was in the record. That's what I presume. Wichita Police Department always uses the same 6-pack in the identifying forms, which I believe is what they were discussing during the colloquy. So I think that there's enough of a description in the record that the court can.
There's a description of how the photo lineup happened, but is there a statement? Do we know the statement in the report that says these people said? I mean, is that what it is, or is it that?
There isn't a quote. There isn't a quote from the witnesses. It's just that the detective says they didn't identify them, is what I think the court is getting at, and I think that is in the record. Sorry. The other issue is that I think that you can admit these lineups as a business record once you get past the confrontation bar, which if the defendant wanted to waive her confrontation rights, then I think it's her right to waive, even if it would let in the good, the bad, and the ugly. I think that's her decision that she gets to make.
And do you think her statements are sufficient to waive, to make it clear that she's waiving her right to confrontation?
I think that if a defense attorney can open the door on accident to waive confrontation by asking questions on cross-examination, then her statements that she wants these things to come in, she knows they're not here, but I want them in. I think they are sufficient to indicate that that's what she wants to do. She wants to get that evidence in. And the state even said there's going to be a lot of other stuff that comes in, but she was still so persistent the trial court had to shut her down so they could move the trial along.
What are the working limits on that, though? I mean, trials have some rules of procedure. Does the defendant's willingness to abandon them end the matter?
I'm not sure. I think in this particular case, the defendant wanted to abandon them and could have abandoned them and moved it along.
How would we limit that? How would you suggest that rule be drawn by the court?
As far as how to like a limited waiver of confrontation?
In the next case, the defendant says, well, I'd just prefer not to have that rule. Well, substantive or procedural affect my case because it's going to, I think it'll benefit me.
I think that I think it has to either be an absolute waiver or I don't think you can start crafting limited waivers. I think that will be unfair and not work. But I think that if she wants to waive confrontation and there are other exceptions to allow the hearsay in, then I think that's her mistake to make or not make, or strategy to pursue or not pursue. But I think that she does have the ability to waive a right to confrontation. It's a personal right that she should be able to waive if she so desires. It's no different than somebody waiving the right to remain silent who probably should have invoked that right. I think that's an ability that she has. The only other thing I would wrap up is that going back to the felony murder rule, identity was the issue perceived at trial. That was kind of the only defense under the old felony murder rule that would afford any sort of relief really at trial. So I think that in light of the new felony murder rule, when you consider all the evidence in the light most favorable to the state, there is other evidence that supports the lesser included. So we would ask that you reverse our conviction and send it back down for new trial. And if there's no other questions, I've run out of time.
Any more questions of counsel? Thank you, counsel.
Thank you.
Both for your arguments this morning. Court will take this matter under advisement.